Good afternoon, everybody. Welcome to this week's Market Huddle. My name is Dylan Malberg. I'm an advisor on the team here at Secure Retirement Financial, filling in for Joe this week, who's taking a little time out of the office the first couple of days this week. So this week with us, we have a special guest, Diana Marianetti of Maslin Law. And she's going to be covering some of the reading of the will and some other common myths and mistakes around death and the probate process. So with that, Diana, I'm going to turn it over to you and we can run through this week's Market Huddle.
Sounds good. Well, hello, everyone. It sounds like we've got a number of people on. It looks like we've got at least 33 of us here. So thank you for being here. You know, the pandemic has really motivated people of, you know, all ages, all types, all wealth to create, to revise, to finalize their estate planning. And one of the things I've realized is just how many myths out there are about the process of creating wills, trusts, healthcare directives, powers of attorney. So what I hope to do is kind of demystify the process, tell you a little bit about some of the myths and why they are or aren't true, or whether there's a little bit of truth to them. I'll try and I've got the chats up here on my screen. So if you have a question, feel free to type it in. If it's something that I can answer quickly, I will. If not, I think Dylan will give you my contact information, and happy to have a chat outside of this. So let's see if I can work this here. Okay, so the reading of the will and other common myths about death and the probate process. The first myth is that there's going to be a reading of the will. I had a good friend who's also a client who is the executor of her grandfather's estate. And one of the beneficiaries was saying, why hasn't there been a reading of the will? You know, what is going on? You know, why haven't we done this? And, you know, after I got through giggling a little bit, what I had to explain is the reading of the will is just not a thing anymore. You know, you see it in TVs and in movies. I think this little picture here is from a movie called Knives Out, which I haven't seen, but I understand there's a really funny reading of the will scene in that. Anyway, it was a thing back in the day when, you know, literacy rates were low, when everyone always lived in the same town. You know, but the scene of dramatic pauses and gasps and the ultimate revelation of what was in someone's will, that just doesn't exist. Occasionally, the person who's in charge, the executor, or in Minnesota, we call it the personal representative, will suggest kind of a family meeting. If there's things to talk about, if there's, you know, controversy within the family, if there's something that would be unexpected or that we need to work out, sometimes we'll have just a little family meeting to kind of discuss the process, kind of do an estate planning 101, just so that everyone is on the same page. You know, a lot of people will say, well, then how will I know, if there's no reading of the will, who the beneficiaries are? And my answer to that is, if you're a beneficiary, you will know. And the reason is in the probate process, which is kind of the court process whereby property goes from the person who died to their successors. In the probate process, there's a notice proceeding. So what that means is, if you are a beneficiary, you are required to get notice that you are a beneficiary. And so you'll get oftentimes a copy of the will, you'll get a notice of the court documents that appoint the person who's supposed to take care of it. You'll receive all of that in the mail, and you have to receive it by statute. So, you know, the other thing is that wills by nature are public record once they're probated. So if anyone wants a copy of a will when someone has died and there's been a probate proceeding, that is all public record. You literally walk down to the courthouse and get that. So there is no reading of the will. It doesn't exist. Literacy rates are high. People are scattered across the United States. You know, we can send a copy of the will by email. We can have a phone call. This is just not something that happens. So this is the kind of the first myth out there. Second myth, again, my good friend, client, she kind of helped me put this together. And one of the things I asked her is, what do you think happens if you die without a will? And she said, well, now that, we've worked together, I know better. But originally I would have said, well, then the state gets everything. That, of course, is 100% false. So the question is then, what happens if you do die without a will? And the answer is that the state has its own kind of default provisions as to what would happen to your property if something happened to you and you did not have a will. Those are called the intestacy statutes. And if you die without a will, the intestacy statutes dictate who will get your assets if you die. When I was telling her a little bit about my good friend about the process and wills, the one thing that she told me that I had to point out to you all is that a will is also the only place that you can name a guardian for your children. So not only does the will dictate where your assets go, but a will is the only place that you can designate a guardian for your children. So that kind of notarized piece of paper that you leave behind, or that little note, is just, it's not effective. It's not legal or anything like that. This is the important one, because, while there's a statutory process to decide who gets your process if you die, there isn't any sort of statutory process for your kids. So what could end up happening is if someone were to die without a will and had minor children, you oftentimes can end up in a big fight. I had a client who, she died at 52. Dad was not in the picture, and she had a 13-year-old. And she had, over the years, told several different people, if anything ever happens to me, I want you to take care of my daughter. The problem is that she told several people that same thing, right? And so when she died and it was time to name a guardian for her daughter, you had like 3 or 4 families trying to step up and say, no, this is what she wanted. And ultimately, in that case, everyone did come to the right place and came to a decision to make the right decision for the kids. But what I'll tell you is that's not always the case, especially, if there were a divorce and some unhappiness. And, I had another case where it's very unfortunate. It was mom was the victim of domestic abuse. And dad was in prison, and mom passed away, and we had all sorts of fights with grandparent rights and who was going to be the guardian. So like I said, it's the only place you can name a guardian for your children. So if you have minor children, if your children have minor children, if you have minor grandchildren, this is super important, even more so, of course, than who gets the money. So again, even though there's a statutory process for who gets your assets, and it really will depend on your family situation at your death. So if you're married, and your spouse survives you, and you have all the same common kids, your spouse will generally get everything. If you have a blended family, it's a little different, and there's a specific process for who gets what and in what proportions. And almost inevitably, it's not what people would end up choosing. The other thing to remember is that even though your will might say who gets what, you have to remember that there are different types of assets. So your will governs what are called probate assets. Probate assets are assets that are in your name alone. Now, let's say, I don't know, you have a retirement account with at Secured Retirements, and they manage that, and you've filled out a beneficiary designation that says something other than what your will says. Well, that beneficiary designation will supersede your will for that one asset. So all in all, I guess the moral of the story is, if you die without a will, the state obviously won't get everything, but it's still so important to have a will to make sure that all of your assets are going to the right people in the right ways, and that, you know, your will, your probate assets, your non-probate assets like your life insurance, your retirement accounts, that they're all passing to whomever they should pass in the right way. And when I say the right way too, again, here, there's an issue of minor children. So let's say, you know, you're single and you have minor children, or one of your children is single and has your minor grandchildren, and something were to happen to them. Another problem if you don't have a will that can arise is minors cannot inherit assets by law. So if something were to happen to someone who had a minor child, what would happen is the court would have to set up this thing called a conservatorship. And that process is really arduous and really expensive. Someone is appointed to take care of assets for the minor child, and they have to go to court and say exactly every year how much they spent and how it was for the children. And you have to do a detailed accounting. And like I said, really arduous. And then when the minor turns 18, they get everything outright in their own name. I don't know about any of you or any of your children at 18, but that for me would not have been a good financial plan. So again, even if the intestacy statutes were to say exactly what you wanted, there are still so many good reasons that it's important to have a will. All right. This is a big one. Okay. If I have a will, my estate will avoid probate. There are a lot of misconceptions about probate. So while having a will definitely provides clarity as to who gets your property and who would take custody of your children, the one thing that a will does not do is avoid probate. To the contrary, a will gets probated. So again, what is probate? Probate is the legal process of administering a deceased person's estate, you know, resolving all their debts and distributing all their property to whom it should pass, either by their will or the intestacy statutes. If there is a will, the court appoints the person who was nominated as the executor, the personal representative. If there isn't a will, that person gets chosen. You know, it can be kind of by volunteer. You know, I suppose another mini myth within this one is that people want to be the personal representative, right? There's always fights over who gets to be the executor. And to me, I truly don't understand those fights, because it is, you're fighting to do all the work, right? You don't really have any power as the personal representative except to do what's in the will, which is collect the deceased person's assets, pay their debts, pay their taxes, and distribute it how it says. So to fight to do that work, which is a lot of work, trust me, my father just died recently, and so I'm still going through that. And even as a trust and estates attorney, it's a lot of work. So that's, like I said, another mini myth is that you want to be the personal representative. You do not want to be the personal representative. If you have someone else in your life who will do that, super. But so anyway, your will gets probated. So the court says, yep, this is a valid will. It was signed properly. You know, it was witnessed properly. This is a valid will. We're going to follow what this says, and we're going to appoint someone to take care of the process. So that said, probate is not necessarily a four-letter word, right? It's not always a bad thing. Of course, if you Google probate, you'll hear all sorts of horror stories about why it needs to be avoided at all cost. And my answer to that is, you know, it doesn't always need to be avoided at all costs. If you do it right, it's a really easy process. In Minnesota here, super, super easy process. You know, a couple $1,000s worth of work, you know, a couple hours of an attorney's time, a little bit of paperwork. No one has to go to court. You get appointed, and then you can move forward. So that kind of brings me to my next myth, which is probate is awful. It's terrible. It's going to tie up my estate for years. The reality here is that's mostly false. So if you can see those two little graphics there, the first one is Cinderella, right? You've got the evil stepmother. Second one looks like presumably 3 siblings who are, looks like my brother and I. The probate process horror stories rarely have anything to do with the probate process itself. Oftentimes it has to do with the family situation. And what I'll tell you is that families are going to fight. If you're going to fight, you're going to fight whether there's a will or a trust or anything. It really depends more so on your assets, your family. The horror stories I hear are almost always false. Now there's some truth to things that probate can take a little more time than if you, for example, have a trust, and we're going to talk about that next. A will will always be, probate will always be smoother if you have a will, that being said, because then you don't have a fight about custody of kids. You don't have a fight about the personal representative. You don't have to prove who's who. You don't have to determine, who the children are, who the heirs are. So when you think of things like the Prince estate, that's been a nightmare because he didn't have a will. It's not clear who his heirs are. Does he have kids? Of course, kids are coming out of the woodworks, right? Who are his heirs? Are they his siblings? Are there, so when there isn't a will, it's always going to be a little bit more difficult. But like I said, it's rarely the case that it is the probate process's fault that the estate gets tied up. A lot of times, there is a wait at the beginning, while we're waiting for someone to be appointed as personal representative. There's also a waiting period where you can't distribute the assets until, there's a creditor period, the time that creditors have to make a claim. But none of those, I feel, are in and of themselves a reason to avoid probate. What I'll tell you is that there are some triggers that make sense for people to avoid probate. And we can talk a little bit about those, but, take this for what it's worth, that, the attorneys in my estate planning group at Maslin, there's about 6 of us. We could do whatever we wanted with our estate planning, right? I mean, I can draft myself whatever I want. All of us have wills. None of us have trusts. Now, none of us, I think, fit the triggers that I would normally say you should have a trust for. But so take that for what it's worth. Not everyone needs a trust. There are certainly law firms that will try and tell you that everyone needs a revocable trust because we have to, avoid probate. I'll give you one guess as to why those lawyers push trusts for everyone. I'll give you one guess. So to me, that is an unethical way to practice. If someone needs a trust, we talk about it. If there aren't any triggers, I think in that case, it's unnecessary cost for the client. It's unnecessary time and, just really unnecessary. So that being said, that leads us to our last myth, which is that having a revocable trust or a living trust, as it's sometimes called, is the best way to avoid probate. Now, there is a good amount of truth to this. Having a revocable trust is kind of just a will substitute, okay? So the guts of the document will look the same. They can go to the same people, but it's a trust that's there for you, for your lifetime. Like I said, there's really no difference between a will and a trust, with the exception of any assets that are in the trust avoid the probate process. Now, Why I've listed this as a myth is that a revocable trust has to be funded in order for those assets to avoid probate. And by funded, what I mean is you have to transfer your assets to the trust. So if you have a home, you have to do a deed to your home, putting it in the trust. With all your bank accounts, you have to retitle all your bank accounts so that they're not in Diana Marianetti's name, but they're in Diana Marianetti Revocable Trust's name. So, it's a lot of work. Imagine changing your name on every single account you have. And why I say it's a myth that this avoids probate is that almost always, I think I've had only a few cases where we had solely a trust administration, is that almost always something gets missed. And there's that one account that you've been hanging on to that you totally forgot about, or that you didn't get time to retitle into the name of the trust. And then you have to do a probate anyway to get that one account into the trust. And you've essentially thwarted your entire probate avoidance planning. I'll admit, my father didn't follow my advice and forgot something, and we had an asset that I had to do a little mini probate for down in his state. He lived in New Mexico. So I had to do that from afar. I had to hire a lawyer down there, which of course was really annoying for me because I know I can do all it. I'm just not licensed there. So it's very rare unless you have an extremely diligent client and paired with an extremely diligent financial advisor and extremely diligent attorney, all three, in order for everything to get funded properly and fully avoid probate. Now, that said, let's talk about some of the ways, some of the triggers in which I do think it would be important to have a trust. If you have property in multiple states, so let's say you have a house in Minnesota and your whole life is in Minnesota, but you have a cabin, or as I understand they're called, cottages in Wisconsin, right? In that case, that probably puts you over the edge in terms of it making sense to have a revocable trust. Why? Because you have to have a probate process in each state in which you have property. So in that case, you'd have to have a probate in Minnesota, and you'd have to have a probate in Wisconsin. To me, that's enough to, I think, justify having a trust. Some of the other triggers would be if you live in a state in which the probate process is, in fact, terrible. And there are some. Like I said, Minnesota is not one of them. But if you live in California, if you live in Florida, if you live in Illinois, those are kind of my big three. Or if you have property in any of those states, the probate processes are a nightmare. Florida costs money to do everything because they want to keep everything in-house there. In California, the lawyers are entitled to a statutory fee for handling the estate. So even if there's one asset, even if there's a $2 million house and that's it, and they spend 2 hours administering their estate, they're still entitled to 2% of the entire estate. So in those states, yes, I think having a revocable trust is a really smart thing. If you're 93 and it's going to be your last estate plan, yeah, I might consider a revocable trust. But for someone who is, 50, 55, has adult kids, all their assets are in Minnesota, they intend to be Minnesota residents for the rest of their life, there's no grand incapacity concerns, more than likely, I'm not going to suggest a revocable trust because although it's not wrong, what sometimes I'll tell people is it's kind of like burning down a house to kill a spider. Right? Will it get the job done? Absolutely. Is it needed? Is it necessary? Is it overkill? Yeah, it's probably overkill. So that said, if you have a revocable trust, though, it's easier to just keep with it. If you already have one, we amend it and we keep going with that process because to the extent you already have assets in there, we want to keep them in there. The last bullet point here is $75,000. That's the magic probate number in Minnesota. So if your state is under $75,000, or if, let's say, the one asset you missed is under $75,000, you can still avoid probate. There's a little small estate process. So, but if you have your entire trust funded, everything is in the trust, and then you had one account that was $76,000, you're going to probate. So that's my last one, I believe. I'll ask Dylan to pop back on. If anyone has questions in the meantime, if you want to just take maybe we'll give you a minute or two and you can type a question. Otherwise, reach out to Joe and Dylan. They can put you in touch with me. And I see Jennifer has a question. She says, what are the costs of getting a trust versus the cost of probate? Good question. So I'll just give you my general fees. So for me, if you're kind of walking in off the street, and let's say you have, you're 50, you have kids who are, either late teens, early 20s. We're going to do a will with a little bit of basic tax planning for you. It's probably going to be in the area of $3,000, maybe $3,500. A trust is probably going to be about $1,000 more than that, so maybe $4,500. So the cost isn't huge between those two. The probate process itself, I usually tell people to get someone appointed, to get through the process of getting someone appointed, it's probably $2,500. So you've got the cost of the will plus the cost of the probate. So let's say, $3,000 plus $2,500, you're looking at, $5,500. But the important thing to remember is that there's also going to be legal costs with administering a trust. I mean, you can't just pick it up. You're inevitably going to have lawyer costs with a trust too. So I would say having a trust, if it is fully funded, and keep in mind you have to spend time and effort and legal fees during your lifetime to make sure it is properly funded, is going to be maybe slightly less expensive upon death to administer. But I would say the cost differential between the two of them over lifetime at death is negligible.
Any other questions out there for Diana? Otherwise, there should be a link up to schedule that secured retirement analysis. Again, whether you're a current client of ours or somebody who's been attending these weekly webinars here over the last couple months, feel free to reach out and schedule some time with someone on our team. Looks like Ron has a quick question here, Diana.
So it says, we have a will and a revocable trust. They were created in Utah, but they were altered and updated when we moved to Minnesota. What would you recommend we do? The lawyer just retired. So the first thing is will and a revocable trust. The reason you have both is your main estate planning document is your trust. But like I said, if something was missed or if there was an asset that didn't make it into the trust, we always do a will as a safety net. It's called a pour over will. And basically you do that little mini probate to pour the assets into the trust. So the beneficiary of the will is the trust. So that's just for anyone else wondering why you might have a will and a trust. So if they were updated when you moved to Minnesota and they still, are what you want, presumably you don't have to do anything. I always like to say you should at least pick them up, dust them off every 3 to 5 years or anytime that there's a big life event. From a tax perspective, I would probably just have them reviewed. There's certain estate tax exemptions to be mindful of that are always changing, and you want to make sure that where your assets are now, that your wills are a good fit. Lawyer just retired. I'm happy to look them over quickly if you'd like. So reach out to me through everyone. Okay, we got several more. Is property the only trigger to across state issues? Real property. Yes, because everything else. So if I have a bank account, that bank account is personal property, and personal property is tied to the state in which you're a resident. Let me know if that doesn't answer your question, Tim. Many people get ill or need long-term care. Is there anything a trust can do to help with this planning? This is a question I get all the time. And there's no magic button for this question. So no, revocable living trust is not going to provide any benefit with respect to medical assistance planning or long-term care planning. That's because more or less that trust is you. It's under your social security number. It's subject to your creditors. Like I said, it's just a will substitute. Now, if you're doing more sophisticated planning and you're doing irrevocable trusts to get assets out of your name, out of your estate, then yes, potentially. What I'll say is for an irrevocable trust to be helpful in that regard, I would say it's a little bit more rare, just because I see it as there's really three ways to deal with that issue. You either self-fund your care by investing really well with these guys. You either self-fund your care, you have long-term care insurance, which is really expensive, or you spend down your assets so that you can qualify for Medicaid. And what I'll tell you is that if you've been living a certain lifestyle, spending down your assets so that you can qualify for Medicaid is you're probably not going to be satisfied with the care you get. So that's why I say there's three options as to how you pay for long-term care, and none of them are great. But a trust isn't going to a revocable trust is not really going to help you with that planning. Okay, my 93-year-old mother-in-law living in a senior complex lost her will. All she has is cash and pay on death account. Do we need a new will? Let me answer that in two ways. One, if she has a copy of the will, or if you can contact the attorney, then you can always probate a copy of the will. If she has cash, cash is a probate asset. So if she has it in a bank account, she could, maybe that's what you mean, cash and a pay on death designation. So if she has one account and that account has a pay on death designation, and that's what she wants, then no, I don't think she needs a will. Who will be the administrator of a trust upon death? Whomever you choose. So it's kind of like your personal representative. You get to choose who gets to be the successor trustee. Oftentimes that's a family member. If there isn't a family member who you would trust or you think would be good at that, there's third-party successor trustees who do it for a living. Obviously they charge a fee, and that's something a lot of people try to avoid, but there's good ones out there if either you don't have someone or you want a third party to avoid controversy. So it's whomever you decide.
Looks like that's all the questions for this week. Diana, again, thank you for your time today. Very informative. If anyone, again, has any questions for us, schedule a time for someone on our team. And if we need to connect you again with Diana or someone on her team as well, we can get you her information as well. So with that, that's going to wrap up this week's Market Huddle. So I hope everyone has a good rest of your week, and we'll hopefully see y'all next Monday.
Bye.